For the last 3 years, we at the Public Welfare Foundation have really invested in the issue of pretrial detention reform. We got started 3 years ago when very few other folks were talking about this issue. The one advocacy organization, the Pretrial Justice Institute, was essentially the only organization on the issue. We were the only funders in this space, and there were very few stakeholders paying attention to pretrial detention policy and problems. Those who are detained pretrial compared to folks who are in the exact same posture, same criminal history, same charge, but who are released pretrial under some sort of supervision. Those detained are more likely to get a worse plea. They're going to more likely get a prison sentence if they're convicted, as opposed to a probation sentence. And if they get probation or prison, they're going to get longer sentences. And as a public defender later in my career, I saw that every day. I saw that my clients who would walk into a courtroom with me from the community were in a wholly different category than my clients who I had to wait for in court because a marshal had to bring them from lockup wearing a jumpsuit and with shackles. When one of those clients of mine would come out, everyone in the courtroom looked at them like they were dangerous. And the truth is that in the vast majority of counties in this country, dangerousness does not correlate to whether you're locked up or not. And the consequences are so severe for those folks. There is a criminogenic effect of holding people pre-trial, that folks who are low risk or medium to low risk or medium risk who are unnecessarily detained in jail awaiting their trial, every day, every additional day of their detention increases their long-term recidivism rates. So Lake Research Partners did a pretty deep dive into what the public thinks about pretrial detention policy when they're educated about it, what their impressions are and their instincts are. And one of the very interesting findings that they came up with that was evident across all demographic lines, across party lines, across gender, across demographics, across age, was that people overwhelmingly supported the use of risk assessment tools. In fact, one interesting finding was that people assumed that the current system already used some sort of risk assessment to make decisions about who's locked up and who isn't, and were surprised and troubled by the fact that currently that's not the case in most counties. The Lake Research polling and focus groups and interviews also found that the public trusts judges, they trust law enforcement, and they want to hear from those folks about what they think about the best way to make the decisions of pretrial release and detention. And finally, the public was very troubled by the concept that there are hundreds of thousands of people who are detained pretrial unnecessarily. They're troubled by the fact that our jails are filled with folks who don't need to be there. And they are also troubled in these tough economic times by the costs of those unnecessary detentions. Another component of our funding in the past has been to attract other stakeholder groups who have a critical interest in making sure that this essential government function works well. And we leverage some incredible relationships that the Pretrial Justice Institute had already developed with the National Association of Counties and the International Association of Chiefs of Police. Both of those organizations have come over these last few years to be our very close partners and collaborators. But in addition to them, we have engaged the National Conference of State Legislators, the National Center on State Courts. We're seeking to make sure that we can help engage all of the stakeholder groups that are involved in the function of pretrial detention. Prosecutors, judges, defenders, jail wardens, sheriffs, police chiefs, law enforcement, and county commissioners who make decisions about money in counties.